And Justin, how are you?
Good morning. Well, thank you.
Yeah. So you've got Mick Veach, chair of the Regulation Committee. Could I ask you to please? I'll start with Beverley. If you could state your name, position, title, and then swear either an oath or affirmation.
Yes, thank you. So, Beverley Smile, President of the Inland Rivers Network, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Beverley. And Justin, if I could get you to go through the same process, your name, the position upon which you're attending, and then to swear either an oath or affirmation.
Yeah, thanks, Mick. Justin McClure, Chairman of the Australian Floodplain Association. I've nominated the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And now, Beverley, would you like to make a short opening statement?
Yes, well, thank you for the invitation for Inland Rivers Network to provide evidence to this important inquiry. Firstly, I wish to declare an interest in that I represent Nature Conservation Council of New South Wales on the Healthy Floodplains Review Committee. A requirement of committee membership was to sign a deed of confidentiality. So I declare that no information provided by me today is a result of my participation in the Review Committee deliberations. Inland Rivers Network considers that there was no justification to enact the exemption for floodplain harvesting on the 7th of February this year as a means of regulating that form of take. A 324 temporary restriction order has broad powers to prohibit the take of water in a specified water source, including overland flows. The capture of overland flows before the water reaches a stream or river definitely impacts on downstream flows. There is still no measurement of volumes of water captured in storages or on fields to quantify what level of floodplain harvesting take actually is. The process of developing a policy then implementing regulation has been very slow in New South Wales. Floodplain harvesting is still free access to water at a time when all other take has to be accounted for. We strongly object to the exemption for floodplain harvesting gazetted on the 7th of February because it gives a legal right to take water that is not licensed and not measured. The wording in the exemption also has the potential to give retrospective approval to floodplain works that were developed without going through an approvals process prior to 2003. The nexus between floodplain management plans and assessment of impacts of floodplain harvesting is very unclear. We have major concerns with the floodplain harvesting policy adopted in 2013 and amended in 2018. This exemption regulation is one of the elements we strongly object to. Other issues include the 500% carryover rule, provision for trading, and environmental assessment of works. There is no provision to assess the cumulative impact of floodplain harvesting on downstream environments and communities. We note that the draft metering policy proposing an exemption for rainfall runoff on developed areas. No one else in the state has this right. And we don't support the 2014 amendment to the Water Management Act, granting compensable private property rights to floodplain harvesting licences before they've been issued. If the final granting of licences and approvals fails to get the shares right, the public of New South Wales may end up paying the price. Water sharing plans are based on floodplain development in 1999-2000, while the policy is based on development as 2008. It is very unclear how this will be reconciled in the assessment process. The capture of first flush flows in February and March this year has compounded the downstream problems. And for example, Wilcannia is very close to going back to high-level water restrictions again. Floodplain harvesting has had a significant unassessed impact on downstream wetlands, native fish populations, Aboriginal cultural and spiritual connection to rivers, groundwater, recharge and downstream communities and other industries on the Barwon-Darling for over 30 years. Inland Rivers Network calls for exemption regulation to be repealed. Floodplain harvesting should be disallowed until it has been fully assessed the cumulative impact, licensed and metered. Thank you.
Thanks, Beverley. And Justin, do you have a short opening statement?
Yes, Mick, I have got a short statement, and if I do have a conflict of interest in this scenario, it's in that I've got a lot of respect for communities, and I've got a lot of respect for people, and I'm a floodplain grazier, and I'm an irrigator on the Barwon-Darling, about halfway between Burke and Wilcannia, and I've seen the flows decrease at Wilcannia in the peak summer months when we need the water most, and I've seen the impact that this decrease in flow has had on our communities and the environment. So I'm I agree with what Bev said, and I won't go into a dot point rendition of what Bev has put forward. But floodplain harvesting is just another impact on the flows and the increasingly decrease in the flows that once were available. While we're not against irrigation per se, we very much wish to see the return of equity to the communities and the environment along the river, and floodplain harvesting and the subsequent actions of this law has had an impact, and I would also like to see that repealed. Thank you.
Thanks, Justin. I might open up with the questions. Justin, in the submission from the Australian Floodplain Association, and I'll quote the statement, it says that it is arguable that the Minister has exceeded her power under the Water Act in exempting such floodplain structures. Can you just talk a bit more about what you mean by that? It's a pretty strong statement, and I just would like you to sort of elaborate.
Okay, I guess I hold a water licence, and that water licence has certain conditions upon it, and one of those conditions is that I shall not impede flood flow to continue downstream, and so my licence is governed by a set of rules that to the letter of the law, and we question as an organisation the legitimacy of legalising structures that haven't been through a process of as if to see if they've had impact on downstream communities and environment.
Okay, thank you. And you also say in your submission, and again I'll quote, there should be a complete embargo on harvesting of overland flows until such time as all licensing, monitoring and compliance measures, as per the recommendations in the Matthews report, are in place. So you essentially, what I'm taking from that comment is that you think it's just there should be a permanent embargo in place until the Matthews report recommendations are implemented.
Pretty well, Mick. That's the way I see it, or we see it. There are a lot of recommendations in the Matthews report and also the NRC report that support full measurement and full assessment, and yeah, that's our position.
Okay, and you also talk about the importance of first flush flows. Can you explain to the committee, in your own words, what a first flush flow is and why are they so important? Why should they progress unimpeded?
First flush flows are basically it rains, rivers flow, and if you live at the bottom of the system, as a lot of our members do, they have been without water in the case of downstream of Menindee for 12 months, and the quality of the water is particularly poor, what water they do have. So the protection of the first flows from the first rains are very, very important to get water down the system. Now, in this case, the rivers themselves were embargoed, and the floodplain harvesting was embargoed. So, hence, the first bit of rainfall must get through to the bottom of the river as quickly as possible to ensure that I guess the requirements of the Act are upheld, and those requirements are, in times of critical human need, those communities at the bottom of the river have protection. So hence the first flush rule is a mechanism to guarantee those flows through the system.
Okay, thank you. Now, I'll ask this question to both of you, but Justin first, and then I'll get Beverley to respond. But essentially, there's been most of the submissions, and even today, some of the commentary we've heard is critical around the communication on the implementation of this regulation and the subsequent order. So, sort of a rushed nature to the introduction of the regulation. Are you critical of the way in which the regulation was brought about?
Yeah, very much so. There's lack of transparency, lack of consultation, particularly with the bottom end of the river. I think that the whole scenario was badly handled, and I think there is a degree of in-house decisions, and when consultation does take place, on the rare occasion, the decision has already been made by the bureaucracy, and that disappoints me greatly. So the lack of transparency in the process and the lack of consultation, because there was basically zero. Okay,
and Beverley, your views around that?
Yes, well, as I said in my opening statement, Mr. Chair, was that Inland Rivers Network certainly doesn't support the concept of an exemption in the first place, but the fact that it was actually in the policy from 2013, government had ample time to develop up an exemption regulation if they were going to put it to use. And it just was extremely disappointing that both the exemption regulation and then the restriction order happened at the same time. And as I also said, there was no need to have the exemption order in place to be able to carry out the restriction on that form of take to allow the very important first flush flow that Justin described for you to get down the Darling River that had been described as a river system in ecological collapse. So we certainly weren't impressed that that exemption, that the restriction order then got immediately overturned. But the whole process was absolutely no consultation with anybody.
Thanks. And Beverley, you also say in the Inland Rivers Network submission that the wording of the regulation is problematic. Can you explain why?
Well, yes. What we've pointed out is that the clauses that describe an eligible work, particularly to do with on or before the 3rd of July 2008, was that it's not taking into account whether those structures had actually received approval or not under either the 1912 or the 2000 Water Management Act, whereas the next point in the eligible work is quite specific for anything that had been developed after that cut-off date. So I just see that that's quite a loophole in the way the exemption's been written, and it could have just been very poor writing of the exemption because it was done so hurriedly. But when you look at the description of eligible works in the actual floodplain harvesting policy, it actually outlines more specifically that anything constructed before the 3rd of July 2008 had to be constructed in accordance with an approval granted under Part 2 or Part 8 of the Water Act 1912, or be subject to, construction under Part 2 or Part 8, there was still an application outstanding, but none of that has appeared in the actual exemption, the wording of the exemption regulation. So that is basically just sort of open slather that anything that's sitting out there on the floodplain, whether it actually went through an approvals process, whether anyone actually ever applied in the first place to be able to develop that structure, there's no consideration around any of those aspects. And that's why I've also mentioned the nexus between the way the floodplain management plans have been constructed. They're supposed to be looking at works on floodplains, and how that's being related to the approval for works around floodplain harvesting is still very unclear.
Yep. And so in your submission, I think it's on page 4, you say this exemption appears to ignore works constructed on or before the 3rd of July 2008, and you go on there to explain much as you just have. And then the next paragraph is, our concern is the regulation, as currently worded, gives an exemption to floodplain works that do not have approval. So essentially, you're talking about retrospective approval. What you're saying is it essentially there's sort of no formal process to this?
Well, it's just really the wording of the exemption. Either it's pretty sloppy or, deliberate. I don't know, who can tell, because there was no consultation. But that's what we see as being one of the glaring problems with the regulation, is that it appears to be giving exemption or really retrospective approval, because the regulation actually now is giving a legal right to the activity of harvesting water off floodplains with all of those works. So that was our concern, whether it is actually a form of retrospective approval.
Okay, thank you. Now I'm going to move on to questions from the committee members, and Justin Field has indicated he's got some questions. So Justin.
Mick, thanks Mick. Just coming live on the video. Hi Bev and Justin, thank you very much for being here. I hope you can hear me fine. I did want to turn to this question of compensation that you raised in your submission and in your opening statements. I noted that you're concerned about the compensatable rights being incorporated into the 2018 amendments, or 2014 amendments, I think, to the Act. And now the concern that this exemption regulation gives potentially an approval without going through the process. I mean, I'll ask the question of the department. They'll say it's an exemption until we've got the process established. But do you have concerns that this exemption regulation effectively, and there's been more works and more take than will ultimately be licensed if it's to be inside the cap? Are you concerned that this regulation will set up a future compensation claim if those levels of take are sought to be reduced once the licensing arrangements are finalised?
I get that's is that to Beverley, Justin?
Well, probably primarily to Beverley. I think your submission goes into this in more detail.
Okay, so Beverley.
Well, I mean that is a possibility, but I was thinking more in terms of the actual shares in the licensing of the take, that if there's an overestimation that is licensed, and then in retrospect the government decides they actually need to claw some of that back, that is when the compensation would be triggered. But in regards to retrospective approval of works on the ground, I'd have to take that on notice, or, you know, we'd need a bit more legal advice on that, I think.
Well, I'm happy for you to take it on notice, Beverley, and the Secretary will get in touch with you about that. Justin, do you want?
Yeah. So the other component of this. Yeah, go ahead, Justin.
Sorry, Justin. We'll get Justin McClure.
If I could comment, Justin, I guess in SAP and in CAG meetings and the general feedback from the irrigation industry is that they will be seeking compensation if there is any impact on their so-called property right, and it is a topic that comes up very regularly in some of the meetings that I'm involved with, and some of the consultation meetings I'm involved in. The irrigators per se are not shy in coming forward and putting their hand up and flagging compensation if any part of their property right is compromised.
And do you think this regulation, this exemption, has strengthened their property right claim? Because until there was actually a volume licensed, the property right that they have, I guess, was questionable. Has this strengthened that claim?
Oh, yes, definitely. It is. Definitely given them the weight of support, the weight of the law, I guess, in that their illegal structures are, or non-approved structures. Illegal is probably the wrong word. They're ill-scrutinised, unscrutinised structures now have legitimacy, which, in my opinion, and the perception is that it definitely gives them weight to their argument.
Now, the other question I have,
leaving themselves completely open to a large compensation claim.
Okay. The other question I have really is around the volumes here. I think both of the submissions sort of go to this point when they were raised in opening statements about, you know, the largely unregulated and unaccounted for take. I mean, the minister and the government, DPIE, have put out a figure of 30 gigalitres maximum of floodplain harvesting take during these events. We've heard other people suggest it is much, much more. I'm trying to get to the bottom of it. Where do you get your confidence that the take is has been sort of largely unaccounted for and is more than the 30 gigalitres that has been put forward by the government?
Well, the fact that there's not one single metre on one single storage that can capture floodplain harvesting means that no one can be certain about volumes until such time as the measuring policy is in place.
Justin McClure?
Look, I've got no confidence in the figure. I had a discussion with the minister early in the piece, and she was talking, to quote, a minuscule amount, and there were some figures bandied around, and the confirmed figure was 30 gigalitres. Do I have any confidence in that figure? I don't. No, I don't have confidence.
If I could just add to that, regardless of the volume and whether 30 gigalitres is a big volume of water or a small volume of water, as far as the very parched and dying Darling River system was concerned, it was an enormous volume of water. And there was, just previously to that, there was a northern basin connectivity flow using held environmental water from the Guida and further up the border rivers. And it was a much, much smaller volume of water than 30 gigalitres. And the justification for having that northern connectivity flow was to top up habitat for our dying native fish, and really important for connecting some flows in the Bow and Darling. So, I mean, 30 gigalitres at that point of time was a significant volume of water for a first flush flow down that river system.
Look, I'd support that as well, in that this rainfall this sequence of rainfall events, which has amounted to 500 gigalitres arriving in storage at Menindee, it's got to be remembered that, as Bev illustrated early in the piece, this was only one first or second rain event out of probably 7 or 8 rain events, and 30 gigalitres at that time was nearly 50% of the water that was predicted to reach Menindee at that stage. So you've really got to put it into context. It was that 30 gigalitres would have been critical to meeting the community needs downstream. And it was only by luck and good fortune that it continued to rain, and subsequent events actually contributed to the eventual result of Menindee. So it's a critical point, I think, in that you've got to judge events or flows on what you've got in your hand. The bird in the hand is what you haven't got. So 30 gigs was potentially 50% of what water could have reached Menindee if it hadn't have rained again.
One last one from me, Mick. It seems there's a bit of a question mark around active take versus passive take when it comes to floodplain harvesting. Is it your position that passive take should be licensed under the floodplain harvesting policy? And how, given a lot of these properties are designed to be able to maximise passive take, I mean, what would have to happen to ensure that passive take that wasn't licensed was able to flow?
You're asking the question. I'll answer my opinion, I guess.
Yeah.
If the properties are designed to take passive take, then there needs to be a provision to pass that first, to let that first flush go. It means these structures, when they're licensed, must have a mechanism to release water to downstream. My licence insists that I don't impede flood flow. Why would a floodplain licence, which hasn't been issued yet, have priority over my licence and all the community and the environment? I just don't get it. There's no consistency here.
Beverley?
So look, if we're talking about a licensed work, as Justin just referred to, any water that a licensed work captures is floodplain harvesting, and it must be licensed under an assessment process. So this passive water is quite a weird definition that's coming from left field. It doesn't appear anywhere in policy, and I think it's just a furphy. Any capture of water off the overland flow, doesn't matter whether it's gravity fed or pumped out of a channel or whatever, it is still capturing floodplain water, and it will need to be licensed.
Okay, Justin, we're going to go to Kate now, who's indicated she has some questions. So, Kate.
Thank you. Thanks, Mick. Thanks, Bev. Thanks, Justin. I just wanted to get a sense, if you could explain to the committee, because you are really, particularly you, Bev, here, one of the sole kind of people or stakeholders, witnesses really talking about the environmental impacts downstream of this decision. I was wondering if you could expand for the committee on the impacts of the embargo, on the impacts of what happened in February on downstream wetlands and ecological assets, and Justin, you as well, of course.
Look, I guess I tried to touch on it before. If it had stopped raining after that event, and the forecast in Menindee at that time had have been 30 GL, and it would have intercepted the other 50% that would have reached the river in broad brush terms. So the Lower Darling has been dry for a long time, 12 to 14 months, I think. The amount estimated to restart the Lower Darling was 30 GL. So the impact on the environment and the communities downstream, in my opinion, was totally compromised by that decision. But the important point is that it was a snapshot in time. It was a second rain event, and the forecast to Richmond was only 30 GL. I hope I answered your question, Kate.
Beverley?
Yes, thank you very much. So, I mean, in two of the Northern River catchments, the Guida and the Macquarie, where there's substantive floodplain harvesting occurring, we have what are called Ramsar-listed wetlands, and that's part of an international agreement that the Australian government has undertaken to look after those wetland areas. And then the New South Wales government is the manager, so having responsibility for keeping those wetland areas healthy. And the business about there being no cumulative impact assessment of floodplain harvesting that's been going on for free, unregulated for 30 years, is that there's no sense of how those important international wetlands have been impacted by this free form of take. But there's also other parts of the whole northern basin that are extremely important for other international agreements that we've signed, and that's for migratory birds that fly to Australia from parts of Asia. We've also signed international agreements that will look after the habitat and the wetlands that these migratory water birds use. So there's a number of significant obligations that both the New South Wales government and the Australian government have, and that's one of the purposes of the Murray-Darling Basin Plan, was to really put water back into the system so that those important wetland areas had a bit of a chance to survive into the future, particularly looking down the barrel of climate change. And then as Justin referred to, the connection of the Northern Basin through the Darling River and the Menindee Lakes into the Lower Darling and then the Murray is really important connection for then the rest of the wetlands down the end of the Murray system that also we have obligations under the same set of treaties. And I think, as the southern irrigators were telling you this morning, because those flows down the Darling have been restricted so much, then it's now the southern basin being required to try and get the water right down to the end of the Murray to meet the obligations there. So there's significant environmental impacts, not to mention the massive fish kills that just shocked everyone so greatly in the last summer. And some of our iconic fish species are listed under federal environment law as being endangered species. So all of this water that we're talking about being captured for free with no metering, no licensing up in the Northern Basin has significant impacts downstream. And I haven't mentioned the Aboriginal cultural heritage and connectivity values with rivers, or the recharge of groundwater systems, which is another really important value of that floodwater coming down from the higher rainfall areas at the top of the Northern Basin rivers, where there's much higher rainfall there than what you've got down on the floodplains, and particularly in the Darling catchment. So, I mean, that lack of cumulative environmental assessment is a key failing of the current policy.
Excellent. Thank you, Bev. Thanks, Justin. That was great. I've just got one more question. During this morning's evidence, we heard from a representative of the New South Wales Irrigators Council, who was essentially saying that, in her words, that this was making floodplain harvesting more legal, So she also said that at the moment, floodplain harvesting is established as a right under the Water Act, that was made 108 years ago. And of course, we heard from other witnesses who were saying similar things in similar language. What do you both make of the comments from irrigators from the northern part of the basin today who have been talking about it as established as a right under the Water Act 1912?
Well, if I could just answer first, Mr. Chair.
Yeah, go if you like.
If there is already a right under legislation that's been repealed, actually, then there would have been no purpose of having this exemption regulation in place. So I don't understand the position that the Irrigation Council's taking on that they already have a right.
Justin, do you have a view on Kate's question?
Oh, look, yes, I do. If it is a property right, then where is the equity? What gives someone a higher right at the top of the system because they live at the top of the hill, the right to deprive similar people along the length of the system?
Yep. Kate?
Yeah, no, thank you. That's good. Yeah.
That's it. I've got no more questions that have been, no one's indicated they've got any questions.
Oh,
so
I do have another question then. I do have another question. Yeah.
Okay, we've probably got
I just thought you'd go. Cool.
Yep,
I just thought you'd go to others. So I just wanted to get a sense in some of the submissions that I've read over the years in relation to floodplain harvesting. There is always this urgent call for audits, if you like, of everything that's happening in terms of floodplain harvesting. One witness today mentioned that the last audit, or there's been one audit undertaken in 2008, and now it's kind of satellite mapping and everything. Bev, do you have some comments around the need for that, or whether what they're undertaking now is you're being assured that it's coming or it's adequate?
Look, until there's a full approvals and licensing system in place with metering in storages, everything else that's going on with auditing and assessment is a guesstimate of the volume of water.
Yeah.
Justin?
Okay.
Yeah, look, I'd support Bev's comment. Yeah, we've got to measure what we're taking now. And until we can measure what's being taken, what's being stored, and we're talking about whole of basin stuff here, then that's the first step. And then we need to have the ability to adjust, wind back to where we need to be with no consultation. Because put things in perspective, because our equity has been eroded or been reversed over the last 40 to 50 years, it doesn't give us the right to seek compensation. And it's probably an important point that if the people in the north can think they're entitled to a property right because losing access to water they've had in the last 10 to 20 years, then the people at the bottom end of the system have the same right on the water that's been taken away from them over the last 40 years. So we need to measure. We need to have the right to reverse that decision within a very short time frame. But if we can't measure, then we don't know who we are or what we've got. So yeah, agree with Ben's scenario.
And now, Kate, Justin's indicated he might have one more question, and we have 2 minutes. So if you're finished, yep, excellent.
Yep.
Okay, Justin, you got the last question.
There should be a quick one. Obviously, we don't have very many large flood events, and we know that a portion of floodplain harvesting is what comes over the banks when it spills, and a portion is overland flows as well. And some of those overland flows might come out of the river originally and pass over multiple properties, might be moving overland more broadly. Can you give me an indication how much floodplain harvesting happens in those smaller events that don't lead to the rivers overspilling, but actually are the capture of just overland flows that would happen in smaller events. How much of that is captured as part of floodplain harvesting, would we know?
Justin, my only comment would be, I don't think it's floodplain harvesting, in my opinion. It's interception flows. What is the definition of floodplain harvesting? And if the definition of floodplain harvesting should not include flows that are intercepted before they reach a stream. So, and I can't give you an answer on that because I don't know. Bev may have an idea.
Yeah, Bev?
Well, I mean, I think the overland flows are equally as important, and that's what a lot of people don't understand. And it just depends on where it happens on the floodplain. You know, a big isolated storm might just dump, you know, a big bucket of water over a small area, but if most of that water then, as it's flowing over the land, ends up in someone's paddock or storage, doesn't end up in the river or creek, then no one else gets any advantage to use that water. But it's very hard to answer a question around volume because of the variability of the system we're talking about.
If I capture water off runoff water for a stock and domestic dam, I think the regulations say I'm only allowed to capture 10% of that particular flow. So,
yeah, and that's the harvestable, right across the state. Anyone with a block of land anywhere in New South Wales can capture 10% of their rainfall runoff and use it for whatever. But once you start capturing above that, you have to have a licence, and that's why I referred to in my opening statement this exemption to rainfall runoff on land developed for irrigation is just another loophole for this same set of people, and that water should be brought under the 10% harvestable rights rule as well. Every drop of water now needs to be accounted for because of the dollar value that's being put on water.
And Justin, we're going to have to leave it there. Yep. Okay. Beverley and Justin, thank you very much for your time and attendance today. The committee is appreciative of your submission and your time. The committee's resolved that answers to questions taken on notice be returned within 14 days, and I believe there was a couple of those taken on notice. So the committee secretariat will be in touch with you about those questions on notice, and the committee members may have a couple of questions emanating from your testimony today as well. So thank you very much for your attendance, and then for the committee members as a whole, we are now we're back at 3:15 with the minister and the department. So people just hang on, or do they?
It's up to them. They can
Yep.